and hope, as always, that everybody is remaining safe. We say that, I don't want it to sound like a matter of routine. We've had a couple of dust-ups in the time since we last met, and it concerns us all greatly. So we do really urge you to remain safe, and we're glad to see that you're safe and well. And our participation rate continues to be high. So thank you for staying engaged with us. As always, these meetings are open to the public, including the media. Since our last call, the Daily Report representative who's been assigned to cover us, Robin McDonald, has since retired, and I was going to say some nice things about her, but if there's anybody from the Daily Report here, please report to her that we did ask and mention her favorably, that we wish her well as she moves on. So govern yourselves accordingly. Ms. Clanton, will you do the roll call vote for us, please?
Happy to do so, Chief. Justice Namias.
I'm here.
Chief Judge Christopher McFadden.
Here.
Vice Chief Rickman.
Here.
Judge Davis will be joining us a little later. Chief Judge Amera.
Here.
Great. I believe we've got Judge Art Smith sitting in for Judge Wade Paget today. Judge Smith? Okay, he will probably join us later. Judge Kite?
I'm here. I'm sorry, I was muted, Ms. Clanton.
Thank you, Judge Smith. Judge Kite?
I'm here.
Judge Cross?
I'm here.
Judge Sizemore?
I'm here.
Chief Judge Asha Jackson?
I'm here.
Chief Judge Christopher Brasher?
Here.
Judge Fletcher Sams? Judge Robert Flournoy?
Here.
Chief Judge Sarah Wall?
Here.
Chief Judge Steph Bagley?
Here.
Judge Jim Blanchard?
Here.
Judge Wes Taylor?
I'm here.
Sitting in for Judge Al Wong, Judge Vi Bennett.
I'm here.
Welcome, Judge.
Thank you.
Judge Lisa Jones?
Here.
Chief Judge Greg Price?
Present.
Judge Kelly Wolk?
Here.
Judge Thomas Lakes?
Here.
Chief Judge TJ Hudson?
I'm here, Mrs. C.
Judge Quinn Casper?
I'm here.
Chief Judge Willie Weaver?
I'm here.
Chief Judge Lori Duff?
Present.
And the President of the State Bar of Georgia, John Jones.
Here. Thank you.
Chief Justice, that completes the roll.
All right, thank you. I also want to welcome Damon Elmore, the new Executive Director of the State Bar, a good friend to those of us who've been with the bar for some time. Glad to have him back home in Georgia, where we all know he belongs. He will be a great asset. A couple of things I want to really focus on during our time. Oh, minutes. Let me move to approve the minute, or at least open up to approve the minutes. Well, okay. We have a motion. There are two sets of minutes, so let's take those as both. Is there a second to approve both sets of minutes?
Second.
All right. Judge Amaro seconds. I assume there's no objection, so those will stand as approved. Thank you. The real focus of our time together is to address two things. The first is the vaccine. We know that there's stage 1A, where the rollout has been in process since the vaccine implementation has started. The court employees initially, and as far as we know, remain in 1B. We have received guidance and some recommended guidance from our task force. We created a subcommittee. Judge McClellan chaired it. They've forwarded their report to our court. Our internal team has been massaging that, but mainly what we're doing is waiting and watching. It is my sense that state leadership is focusing on the lessons learned in 1A process. They are still engaged in 1A, and we're waiting to see when the next stage might be implemented. But until then, I anticipate that there might be some tweaking, And rather than shoot at a moving target, we're going to let that develop a little bit further before we start issuing further guidance as to how the judiciary should interact with the next rollout phase. So we are intentionally not saying anything right yet because we're not sure. We have a good idea what we think we need to say, but it could change, and we're just going to say it once, hopefully. So that's the plan for now. So we are engaged. Hold tight if you can. As soon as we have real firm direction as far as rollout, we'll know what to say about how we're going to do that. So that's that. The second thing I want to point out is we are entering into the next iteration of our judicial emergency order. I have not circulated a draft to you guys. I have not bothered you with that, largely because it is 98% the same. The one thing I want to point out to you is that we hope to be able in the March order to open up jury trials again. So in the order that will go out on the 7th, we signal that we hope to be able to open up jury trials in March. That depends on a number of things. Our numbers are looking good right now. We hope those numbers to continue to decline. We also would like to have a greater certainty about the vaccine process, and also a greater certainty about how that vaccine interconnects with those strains that we keep hearing about. And so if things continue to show themselves as favorable, barring any setbacks, our hope would be able to open up jury trials in our March order. That means that if you hope to be able to hit go right away, you already have the authority to issue summons and get the paperwork out necessary to tee those jury trials up. So if that's your desire, now would be the time to make the move to be ready to act as soon as possible in that regard. As we go around the table, if you have feedback about that or the vaccine or anything else, please use that as your opportunity to share or ask questions, and we'll try to go from there. That's what I have. I know the task force has been meeting. I know they don't have anything in addition to what I just shared to report to you. And so I will move to the presiding justice to give his report about the work of the Standing Committee on Legislation.
Thank you, Chief. The Standing Committee on Legislation met last Friday, January 22nd, to consider 3 proposals from the task force that are related to the judicial emergencies in the pandemic. Tracy Mason sent you out information and draft language in your materials for this meeting. I'll highlight a couple changes in the motions that were approved on Friday as we've looked at this some more on specific language. 2 of these provisions, I'll also note, have sunsets and 1 does not. And just a reminder, we vote on these in concept. The specific language may be adjusted as we go through the legislative process. The first proposal is that the committee recommends Judicial Council support legislation to amend OCGA Section 17770 and 17770.1 to expand the statutory authority for district attorneys to use accusations rather than indictments as formal charging instruments, except for cases involving the serious violent felonies, the so-called 7 deadly sins, and only 45 days or after or more after charges are filed. That is to ensure that arrested suspects have the opportunity to get a commitment probable cause hearing. And this authority, the motion on Friday was to expire 1 year from the date of enactment. Having considered this and talked to some legislative folks further, that would be changed to be a 1-year sunset expiring June 30, 2022. So it would effectively, it'd be 1 year, but rather than from the date the governor signs it, it would be till June 30, 2022, which is a fairly standard sunset date. Basically, the way the law works now, a defendant can waive accusation, can't waive accusation, even if a defendant wants to, in a capital felony And then there is a series of crimes in 17770.1 that the General Assembly about 20 years ago allowed district attorneys to charge by accusation. The concern is with grand juries not very active and a big backlog of cases, if cases can begin with the filing of an accusation, they can move forward in the process so that judges can move them along. A lot of times we know in some of the big metro counties, judges are not even aware that a case has been filed until it's formally charged. And also it will potentially allow you to resolve cases without jury trials where that can be done. This has been talked about an awful lot in the task force. There was initially a fair amount of opposition from the criminal defense bar, but particularly with the addition of a sunset and the addition of the 45-day kind of waiting period so that it can't be used to keep arrested people from getting a probable cause hearing, it appears that this is a consensus proposal or close to it right now. So with that, I'll make the motion that the full Judicial Council approve this proposal to amend 17770 and 17770.1.
Second.
All right. Are there any questions or any discussion? All right, Chief, do you want to?
Yes, is there anybody opposed to this recommendation, this proposal? All right, that will stand approved. And remember, we're voting by showing opposition if you oppose. Otherwise, we assume that you're for it. All right, PJ?
The next proposal is on alternative locations. The Committee on Legislation recommends that Judicial Council support legislation to amend OCGA Section 15618 to facilitate the identification and use of alternative locations for superior and state courts as provided during judicial emergencies under OCGA 38361C, 15.6.17b, and Uniform Superior Court Rule 45. This was the only change from Friday, as this was submitted with the working title of alternative location for superior courts, but it actually applies to state courts as well. So we're just going to call it alternative locations. And what it does is right now, if there's a judicial emergency, as many of you have learned, you can only designate an alternate location that is county owned or county leased property. This would allow you to go anywhere where you can have open court that is a contract with the county governing authority. So it would open it up if there's municipal properties, school board property, churches or synagogues or temples that have a room you could use. Really opens it pretty wide to find additional space to use in an emergency. The act as it stands now is a population act, which means that it can't be amended. It can only be replaced, repealed and replaced, which is why this appears as a kind of start from scratch provision. I think we also circulated the old version, but again, the main thing that is being changed is getting rid of the limitation to county owned and leased property and making it any property the county governing authority contracts with. And this one would not have a sunset. This is one that we've realized is just kind of a good thing to change in judicial emergency law, and no real need that we see to kind of do a test run. So that is the motion from the Committee on Legislation.
All right, is there a second?
Second.
Judge Romero seconds. Any further discussion? Any discussion at all? Anybody opposed? All right, thank you. That will stand approved.
All right, and the final one for approval today is The Committee on Legislation recommends the Judicial Council support legislation to amend Article 1 of Chapter 7 of Title 17 of the OCGA to allow a trial court the authority to approve an accused waiver of the right to jury trial and proceed to trial by the judge alone, notwithstanding an objection by the prosecuting attorney. And this authority, on Friday, we had set a sunset of April 1, 2023, much like the first one. We would adjust that to be June 30th of 2023. So basically a 2-year sunset to a common sunset date that's used. This is designed essentially to abrogate a decision of my court called Zygan v. State, where the Supreme Court held a number of years ago that you cannot have a bench trial if the prosecuting attorney objects. Whatever the merits of Zygan, what it essentially does is, even if the defendant wants to waive the constitutional right to a jury trial and the court in its discretion is willing to have a bench trial, a prosecutor could block that. And so this would eliminate that, again, as a means to potentially move cases without the need to bring in jurors. It would only be triggered again if the defendant waives their right to a jury trial, and then the judge would have to determine in the judge's discretion whether the judge is willing to do a bench trial. It is written so that the judge should consider any objection by the prosecutor, but that objection is no longer a bar to a bench trial. There is some concern about this from the prosecuting attorneys, and so the sunset provision is included, a 2-year sunset. Hopefully that'll be far enough to help us work our way out of the backlog of at least some of the cases that right now would require jury trials. And that is kind of an overview, and I would ask for a vote on the committee's motion.
All right, so there's a motion.
Second.
We have a second. Any discussion on this?
This is Judge Jackson. I just have a question for PJ Namias. Does it exclude a certain class of cases? Where were we with that provision?
No, this one, as voted on by the task force and then by the legislative committee, would not exclude any felony cases. Although obviously judges may consider certain felonies in their own discretion more or less amenable to a bench trial.
Thank you.
All right, good question. Anybody else? All right. Anybody opposed to this proposal? All right, that will stand approved.
All right,
All right.
we have one more item just for information, Chief.
Yes, sir.
And I don't know if Tracy has the statute. So the Council of State Court Judges has noted the existence of this statute, which many of us were unaware existed. But 17631E, which should be up on your screen, provides that if the prosecuting attorney doesn't try charges within 1 year, well, 2 years for a felony or 1 year for a misdemeanor, after the date a secured bond is posted, the security on the bond basically becomes exempt from enforcement. That period is extended if it's the defendant's fault that the trial was delayed, but if the trial is simply delayed due to backlogs or other actions like that, the security under the existing statute goes away after a year for misdemeanors, 2 years for a felony. There are some questions about how the judicial emergency orders affect this. That's a little complicated. And if you have those questions, I'd suggest you call Judge Wes Taylor, who's become, I think, unfortunately, the guru on this. But I wanted to alert folks that it is a concern given the backlog of cases, and that will continue even when judicial emergencies end. And so the Council of State Court Judges will be submitting a proposal to amend these timetables, I think to double them to 2 years for misdemeanors, 4 years for felonies, That should circulate tomorrow to the members of the Legislative Committee. Our meeting Friday, our regular kind of update meeting, will again be a formal meeting to vote on this proposal, and there may be a related, more technical bond proposal with the goal of having that recommendation come back to the full Judicial Council at the general meeting on February 12th. But we wanted to make sure folks realize this statute is out there, and there will be a proposal, I believe, to extend the time periods. I'd be happy to take any questions, Chief, or we can wait till Friday to talk about that in more detail.
Any questions now? Okay. I think did you have one more, PJ?
No, that's it. Thank you.
Okay. Well, Justice Namis, do thank you and your committee. As with everything else with the bench during this time, everybody's required to do more, and your committee has definitely worked harder than we typically would have to in dealing with a lot of different issues coming up on the fly. And Judge Taylor, thank you for bringing that item and others to our attention. Let's go around the table. Chief Judge McFadden, do you have anything to report?
Nothing to report.
Judge Walt Davis with the Business Court, were you able to join us?
I am, Chief Justice. Thank you. Nothing to report.
All right, thank you. Judge Amara, I see you. Council Superior Court judges.
No report. Thank you.
Judge West Taylor with the State Court judges.
Nothing further to report.
Judge Kelly Walt, Probate Court judges.
Nothing to report.
Judge T.J. Hudson, Magistrate Court judges.
Yes, sir, Chief Justice. I just want to give an update on the CDC moratorium that came out in the early fall, and our council immediately appointed a small committee to work on guidelines to distribute to our judges. This caused a bit of confusion and frustration in the public since the CARES Act had just expired a month or two prior, and our courts were attempting to restart court dates to address the backlog. There was almost an immediate court challenge to the CDC order, which also complicated matters. The extension of the moratorium came with a second stimulus package, and it also included rental assistance for both landlords and tenants. Our judges couldn't be involved in the distribution of stimulus funding, but our council was asked to begin looking at how this new funding might affect the courts. A few examples of funding distribution from other states was provided. A few of our judges started a discussion of how to best help the public in our courts, could encourage funding applications rather than evictions, but ultimately the distribution of funds or even where the funding was available was not in the purview of our courts and judges. Last week, with the announcement of the extension of the order again, we once again discussed how availability of funds would affect evictions and review several of the metro area counties programs that had recently been developed to distribute funding. Reviewing the current programs in Georgia, we quickly realized that most of Georgia's counties would be left out since most counties didn't qualify to get their own funding, and we would need to rely on the state. We wanted consistency, uniformity, and also an equal opportunity for all Georgians to have access to the new funding. We felt that the best way to do this was to get in contact with the Department of Community Affairs, and they would help us with this. We asked the Chief Judge to reach out and see what they might be doing to help our state. And we were able to set up a conference call with our leadership, members of the Supreme Court, and the Commissioner, Deputy Commissioner of the DCA. They already had a game plan for distribution with a goal for going live on March 1st. They welcomed our interest and wanted us to help disseminate information. This was perfect as we could provide both the communication and email list for them to do. Our Executive Director, Sharon Reese, will be working with the Deputy Commissioner of DCA to both share the Chief's email list and also provide the background on their program to our courts in the state. So that's my report, Chief Justice.
Thank you, Judge Hudson, and thank you for your counsel's willingness to engage in leadership, really. This is something that, as we know, really meets needs, not just of the tenants, but also the landlords. It can provide a win-win proposition for both, and ultimately maintain a portfolio of affordable housing that can remain an ongoing source into the future. So we wish you all well in that endeavor. If we can help in any way, I hope you'll let us know. Judge Willie Weaver with the Municipal Court.
No report.
President Don Jones, State Bar.
Good afternoon, everyone. I have two brief items to mention, Chief. One is that our next Board of Governors meeting for the State Bar of Georgia will be held this spring from March 19th through March 21st, with our Board of Governors meeting being held virtually on March 20th, Saturday morning, starting at 9 a.m. The entire spring meeting will be virtual based on our current COVID stats. It's a joint meeting with the YLD, so we will have a significant number of YLD members participating throughout the spring meeting. And as always, we welcome any judges and any other guests who want to join us virtually. Secondly, and hopefully I will say as an aside, hopefully we will not go beyond the record that I believe we set in this mid-year meeting in January, where we met as a Board of Governors for approximately 6 hours and 15 minutes. We got a lot of work done. Second item I want to briefly mention is that the State Bar continues to, through my discussions with the Supreme Court liaison, Justice Peterson, we continue to share attorneys' concerns, firsthand accounts that we receive of folks who are concerned about COVID-related issues in hearings and courtrooms, mainly and usually in conjunction with their concerns about a lack of virtual options, combined with lack of social distancing, masks not being required or not being consistently used, that sort of thing. And so I wanted to make sure you all know. I've had a number of judges reach out to me. When I hear individual concerns, I reach out to those chiefs who've asked me to give them a heads up. But I'm continuing to share that information directly with the courts of those firsthand accounts. So thank you.
Thank you, Ms. Jones, and we can never be reminded too much of those safety precautions, so thank you very much. Council of Accountability Court Judges, Judge Gosselin.
Yes, Chief Justice. We had our semi-annual meeting on the 22nd of January and approved some pandemic guidelines for accountability courts that we developed after gathering information from all the different courts across the state about what they would like to see in those guidelines. So those are available on the CACJ website.
Very helpful, thank you. Commission on Dispute Resolution, Ms. Johnson.
Thank you, Mr. Chief Justice. We have nothing to report today.
Thank you, ma'am. Council of Superior Court Clerk, Mr. Holloman, are you there?
I'm here, Chief Justice Tina Robinson. We have nothing to report. Thank you.
Okay, thank you. Commission on Professionalism, Ms. Greer.
Hi, good afternoon, Chief Justice. Just briefly, I want to dovetail on what President Jones said. The Commission will be holding a CLE on March 19th during the morning, sometime between 8 and 12. We're waiting to confirm an exact time, entitled The Necessity of Unparalleled Unity. We have sent out 7 invitations for panelists. We've gotten back 3 confirmations from Justice McMillan, Mr. Jake Evans, and Mr. Ashley Bell. And so waiting to hear on the other 4. It'll be moderated by Professor Tanya Washington from Georgia State. And Chief Justice Melton, thank you for agreeing to be present and bring remarks in some form, and to you as well, President Jones. We look forward to that CLE. Please continue to save the date of April 30th, 2021 for the Suicide Awareness Program. The general information is up on the Commission's website. I probably won't open registration until March, until after our State Bar's spring CLE. But please save the date, April 30th from 2 to 5. It will be all virtual, as well as the March 19th CLE. Thank you.
Thank you. Council of Court Administrators, Ms. Robin Rooks.
Good afternoon, Chief Justice. We have nothing to report. Thank you.
All right, thank you. ICJE, Mr. Ashworth.
Chief Justice, we have nothing to report. Thank you, sir.
Thank you. And JQC, Mr. Chuck Boring.
Nothing to report, Chief Justice.
All right, I skipped over our lovely and inestimable, that is, Director of AOC, Ms. Cynthia Clanton.
Thank you, Chief. Well, the AOC remains fully functional. Let us know how we can help you. We look forward to seeing Judicial Council members at the upcoming general session on February 12th, which is next Friday.
Hey, Chief, I've got to clarify one point. Chief Judge Jackson asked if any felonies were excluded from the legislation that would allow bench trials. There are no felonies excluded, but just to be clear, death penalty cases, actual cases in which the death penalty is being sought, are carved out of the statute. So you can't have a death penalty bench trial over the objection of the prosecutor. Just wanted to make that clear.
Thank you. All right. I don't have any old business. Last thing I will share with you is that, as Ms. Clanton just mentioned, our next meeting will be Friday, February 12th. So there's no need to meet this coming Monday. You will see an order come out sometime before the 7th. That will be as described. And until then, you stay safe, and we look forward to seeing everybody then. All right. Thank you very much, folks.